Welcome back to the Socially Distant Lawyer presented by Callahan and Fusco. I'm Mitch Hayes.
And I'm Greg Vinogradsky.
And today's topic is going to be business interruption. And specifically, we're going to be talking about a case that was recently filed in the New Jersey District Court between a restaurant owner and its insurer. For a more comprehensive overview of business interruption and a better understanding of it, please check out our YouTube channel where we provide more content for you. Briefly, business interruption is there for businesses to recoup costs and expenses that they normally would have incurred, but for an act that prevents the business from being open. Normally, we're seeing that in the property context. Greg, why don't you tell everyone what the context of the case is that we're going to be talking about?
Yeah, so this particular case was filed in District Court in New Jersey and essentially asks a couple questions, right? What caused the closure of the business? Was it the virus? Was it the executive order? And does it even really all matter? This particular case was a restaurant owner who had to close because of the executive order by Governor Murphy. During that closure, filed a claim with his insurance company for under the business interruption policy, which was denied by the insurance company. He subsequently filed a lawsuit against the insurance company demanding payment under that policy and is trying to turn that into a class action lawsuit against that insurance company right now. And I know, Mitch, you took a look at the complaint and some of the allegations in it. Why don't you go over it a little bit?
Right. So the plaintiff in this case purchased an all-risk policy and expected to be covered for all risks. However, that's not the case, as their insurance company had denied coverage. So the biggest argument and the main argument that plaintiffs are advancing in this case is that the forced closure of their restaurant was due to Governor Murphy's orders and not the virus. There's a specific exclusion in the policy for virus. However, the civil authority endorsement that they had to their policy is what they're saying is effective, and that the proximate cause was the civil authority of Governor Murphy and the state enacting these policies to prevent and also preclude people from coming into the business and the business from operating at full capacity. And therefore, they sustain losses that they normally would have incurred. So that's one of the main arguments. The other biggest argument is that the insurance company breached the contract. How'd they do that? Well, they said that they weren't going to pay out the business interruption claim, even though it was covered in the contract. And the last issue is that the insurance company that was sued in this case has already issued a memo to its insured saying that it will not pay for virus-related coverage. It will only pay if the subject property at issue is physically altered and physically damaged. So those are the three main causes of action that are being alleged by plaintiffs in this case. Now, Greg, if we got this into the firm and it came across your desk, how would you set up this as the initial defense, and what arguments would you put forth?
Yeah, Mitch, so I'd make a couple arguments, one in policy and one in contract interpretation, right? And the first argument essentially is that you're wrong, is that the closure was caused by the virus, not the executive order, right? The widespread pandemic virus that has impacted every community. And there is no way an insurance company can provide coverage for all of those losses, for all of those business losses that they could never contemplate having to do. They'd go bankrupt, right? So to make them do that would just be unconscionable, right? The other argument is essentially one of contract interpretation. It is one of read the terms. If there's no ambiguity, you have to enforce that contract that both parties contemplated. And in this particular case, there is an exclusion for the virus, which was the cause of the closure. But for the virus, there is no executive order, right? But for the executive order, there is no closure. You have to take it back to the virus. And in the contract, it's specifically included to provide coverage.
So normally we leave you with takeaways after these episodes. Today's takeaway is that this is an evolving area of law. Read the policies, understand the arguments, and know that there's going to be more cases that are going to be filed, and there's going to have to be a determination that's made. Most cases are going to be filed as class actions so that there could be consistent factual and legal determinations. And then there could be one issue that would probably ultimately get appealed. But stay tuned as we go through these these next couple of weeks, because there's going to be more cases that are filed, and there's going to be legislation that is in the process of being enacted and may be voted on. So we'll be sure to update you as more of these issues come up. Stay tuned, and we'll see you next time.